This is the brief on the legal rules protecting your home from illegal searches. We're breaking down Articles 128, 129, and 130 of the Revised Penal Code, which actually slap public officers with jail time and fines for violating your domicile, proving a badge isn't an all-access pass. Think of a judicial order or search warrant as the ultimate VIP pass. Without it, the state is literally just trespassing. First, let's talk warrantless entry. Under Article 128, if an officer barges in against your will, searches without consent, or refuses to leave, they face real prison time, known as prison correccional. Penalties even jump for nighttime offenses. Now, you might be wondering, can an officer just say your stunned silence was consent? Well, no. While silence can be an implied waiver, mere suspicion doesn't justify a warrantless search against the owner's will. Second, what if they actually do get that VIP pass? Under Article 129, they can still face jail and up to a 200,000 peso fine if they lie to a judge to get the warrant without probable cause or use unnecessary severity while executing it. So why penalize someone who has the right paperwork? Because a legal document is not a license to act like a wrecking ball. Finally, Article 130 strictly limits who is watching. Even with a valid warrant, officers absolutely cannot search a domicile without the owner, a family member, or two local witnesses in the room. Wait, does this mean your neighbors need to watch them search your car? No way. This rule specifically excludes vehicles, showing just how sacred the physical home is under the law. Ultimately, these specific penal codes draw a hard line in the sand, ensuring that state power never overrides the fundamental right to privacy within your own walls.
Welcome to this video on breaching the threshold, legal protocols and liabilities in domiciliary searches. We will be examining Articles 128, 129, and 130 of the Revised Penal Code. The law establishes an absolute barrier between state power and the private domicile. The domicile is fundamentally inviolable. The sole exception is a valid judicial order or search warrant. These articles apply exclusively to public officers or employees, serving as checks on state overreach. The status of the warrant dictates the nature of the crime. No warrant results in Article 128, violation of domicile. A flawed or abused warrant falls under Article 129, malicious or abused warrant. A valid warrant with procedural failure is Article 130, search without witnesses. Article 128 defines the warrantless breach. The core definition imposes a penalty on any public officer who violates the domicile of another without judicial authorization. Crucially, mere suspicion is not a sufficient basis for a search without a warrant, even if incriminating evidence is found later. There are three actionable offenses under Article 128: unlawful entry, unlawful search of papers or effects without consent, and refusal to leave the premises after being explicitly required to do so. Qualifying circumstances elevate the penalty under Article 128 from the minimum period of prison correctional to the medium and maximum periods. These circumstances include committing the offense during the nighttime or withholding non-evidence after the search is concluded. Article 129 punishes the malicious and the abusive. It imposes liability on a public officer who procures a search warrant without just cause, or exceeds their authority, or uses unnecessary severity in its execution. Penalties include imprisonment and a significant financial fine. Liability under Article 129 can arise from two paths. The pre-execution phase involves malicious procurement of a warrant without just cause. The execution phase involves abusive execution, where a legally procured warrant is violated by exceeding boundaries or using unnecessary severity. Probable cause is a prerequisite for a valid warrant and judicial authorization. Procuring a warrant without probable cause is an Article 129 violation. Evidence seized without a valid warrant triggers the quote of the poisonous tree doctrine, leading to absolute inadmissibility. Article 130 isolates procedural failure. It punishes a public officer with a legally procured search warrant who executes the search without the strictly required personnel. The officer has the legal right to be there and to search, but still incurs criminal liability due to procedural lapse. A lawful search requires a legal search warrant, a public officer, and the presence of at least one of these: the owner, any family member if the owner is absent, or two witnesses residing in the same locality. The absence of all three renders the executing officer criminally liable. This diagnostic matrix summarizes the breaches. Article 128 involves no warrant and illegal entry. Article 129 involves a maliciously obtained or abused warrant, focusing on lack of just cause or severe execution. Article 130 involves a valid warrant, but a search without specific witnesses. Here is a map of the spectrum of legal penalties. Article 128 starts at prison correctional min and scales up. Article 130 focuses purely on procedural failure with a penalty in the medium to maximum periods of arresto mare. Article 129 includes a significant fine, specifically targeting the weaponization of the judicial system. There are critical legal exclusions. A lawful arrest permits breaking into an enclosure, superseding the quote against owner's will provision. A search strictly outside the dwelling is not covered by Article 128. Finally, Article 130's witness requirement does not apply to searches of vehicles or other mobile thresholds. The Revised Penal Code ensures that the physical threshold of the private domicile remains the ultimate check on state power. A lawful search requires 3 pillars: authorization under Article 128, integrity under Article 129, and procedure under Article 130. A failure in any pillar transforms the state's protector into a criminal offender.
Hey, welcome to The Explainer. You know that old saying, a person's home is their castle? Well, it turns out that's not just a cute phrase, it's actually a legal fortress. Today, we're going to dig into the laws that make your home a protected sanctuary, and more importantly, what your rights are when that protection is put to the test.
So this idea of your home as a fortress, it's not just some poetic concept. It's a fundamental right literally woven into our laws. These rules are there for one big reason: to protect your privacy from getting trampled on. But, the real test, well, that comes when there's a knock on the door, and it's someone with a badge. Knowing your rights in that exact moment is everything.
All right, here's the game plan for today. First up, we'll talk about the big idea, your basic rights at home. Then we'll get into the nitty-gritty of what happens when police want to enter without a warrant. After that, what if they do have a warrant but misuse it? We'll cover that. We'll also break down the rules for how a search is supposed to be done. And finally, we'll look at the penalties, because these rights have real teeth.
Okay, let's kick things off with the absolute foundation of all this, your domicile. Now, in the eyes of the law, your home isn't just a building or some property. Nope, it's your private sanctuary. It's the one place where you have the highest possible expectation of peace and privacy. And really, this one core idea is the bedrock for everything else we're going to talk about.
So that naturally leads us to the biggest, most common challenge to that sanctuary, right? An officer shows up at your door, but they don't have a warrant. This isn't some gray area. It's covered specifically by Article 128 of the Revised Penal Code, and it has a very clear name: violation of domicile. And Article 128 gets super specific. It actually lays out 3 different ways an officer can break this law. But here's the most important part. They only have to do one of these things to be in violation. Just one. They don't have to do all 3. So just entering your home against your will is a crime, period. Even if they don't search for anything. That really sets a high bar for law enforcement. And for good reason. Now that phrase, against the owner's will, is huge. It usually means you have to say no. If you're silent or you just step aside, that could be seen as you giving consent. So you have to be clear. But there's a really big exception here. An officer is allowed to enter your home if they're making a lawful arrest. But, and this is a major but, they can't just do it on a whim or a gut feeling. A mere suspicion isn't enough. They need actual solid probable cause. The law is also smart about context. For example, if this kind of violation happens at night, it's considered a much bigger deal. And that makes sense, right? We all feel more vulnerable after dark. And another thing, if officers see stuff that has nothing to do with the crime, they have to give it back immediately. If they don't, that makes their offense even more serious.
Okay, so what if the officer actually shows up with a warrant? Is it game over? Is that a free pass to do whatever they want? No way, absolutely not. And that's where Article 129 comes in. This one is all about what happens when officers abuse the legal power that warrant gives them.
Article 129 basically covers 2 types of abuse. The first one is about getting the warrant in the first place. If an officer gets a search warrant maliciously, without any real just cause, that's illegal. The second one is about how they use a valid warrant. If they go beyond what the warrant allows or use unnecessary severity, that's also illegal. So it's a check on both why they got the warrant and how they carried out the search.
All right, so let's say an officer has a legitimate warrant and they're executing it properly. You think that's it, right? Well, there's still one more crucial rule they have to follow. It's a procedural safeguard designed to make sure everything is transparent and above board. And this one is covered by Article 130. Here's the deal. To stop any potential abuse, the law demands transparency. A search simply cannot be done in secret. The homeowner or a family member has to be there to watch. And if they're not around, then 2 witnesses from the neighborhood have to be present. This isn't some polite suggestion. It's a hard and fast rule. It's there to make sure nothing shady happens, like evidence being planted, and to keep the whole thing legit. So, we've talked a lot about the rights, but what about the or else? What happens when these rules are broken? That's what our last section is all about, the consequences. Because these aren't just guidelines. These are laws with serious penalties attached, all designed to make sure public officers are held accountable.
And this chart really spells it out. Look at this. For a straight-up violation of domicile under Article 128, you're looking at prisión correccional. That's 6 months to 6 years in prison. For abusing a search warrant, it's arresto mayor. That's 1 to 6 months, all the way up to prisión correccional, plus a hefty fine. Even just doing a search without the right witnesses can land an officer with an arresto mayor penalty. These are not just slaps on the wrist. We're talking serious jail time, which just goes to show how fiercely the law guards your rights at home.
And that really gets to the heart of it all, doesn't it? All of these laws are about finding a balance between the power of the state and the liberty of the individual. And the big question for all of us today is that balance still in the right spot? With all the new security concerns we face, how do we protect public safety without letting our homes stop being our fortresses? Definitely something to chew on. Thanks for joining us on The Explainer.
Imagine waking up at like 3 in the morning. Your heart is just absolutely pounding.
Classic nightmare scenario.
Right, exactly. There is a flashlight beam cutting through the darkness of your bedroom. It's shining directly into your eyes. You're squinting against the glare, and you realize there is an armed stranger standing at the foot of your bed.
It's terrifying. Just pure panic.
Pure panic. But then as your eyes adjust, you see the uniform, you see the badge. And, the most terrifying realization hits you. This armed stranger is an agent of the state.
Yeah.
And they claim they are legally allowed to be standing over you while you sleep. I mean, we inherently believe our home is this impenetrable fortress, right?
We do. We really do.
You close the door, you turn the deadbolt, and the outside world just ceases to exist. It's your sanctuary.
That's the ideal anyway.
Right. But step into the labyrinth of criminal procedure, state power, and penal codes, and you quickly discover that the solid wooden door of your home is far more permeable than you ever imagined.
Oh, absolutely. The clash between the sanctity of the private home and the investigative power of the state is, it's arguably the most volatile friction point in modern law.
It really is.
Because the state possesses the monopoly on legitimate force, right? They have the guns, they have the badges, and they have the mandate to uncover crime.
But the home is the ultimate boundary line.
Exactly. When a public officer crosses that threshold, the legal architecture governing their every movement, their every question, and their every glance just shifts dramatically.
Oh, wow.
We are looking at a system designed not just to guide law enforcement, but to actively penalize them if they misstep by even a fraction of an inch.
Okay, let's unlock this. Today, we are taking a deep dive into tearing apart that invisible legal shield that surrounds your physical home.
It's going to be a fascinating journey.
It is. We have a stack of legal texts here, specifically focusing on the Revised Penal Code, Articles 128, 129, and 130. We're going to dig into the specific, highly structured mechanics of what actually constitutes an illegal search.
Right, and how the law punishes the weaponization of search warrants, which is a huge deal.
Definitely. And we'll look at the incredibly stringent procedural hurdles designed to protect you from a rogue government agent. We are bypassing the basic definitions here. You already know what a search warrant is.
Yeah, we don't need to rehash the basics.
Exactly. Instead, we are looking directly at the escalation of state power through the lens of a specific legal framework, primarily focusing on the principles enshrined in criminal laws concerning the violation of domicile.
The domicile being your home, your sanctuary.
Right. So let's start with the absolute baseline, the rogue entry. Before we even bring a judge or a piece of paper into the equation, we need to look at what happens when a public officer simply decides to walk into your house.
Well, first we need to define the actor here. The framework we are analyzing specifically targets public officers or employees.
So not just some random person on the street.
Exactly. If a civilian neighbor kicks your door down or, burglar picks your lock, the law treats that as trespassing or breaking and entering.
Which are still crimes, obviously.
All right, but those are crimes between private citizens. When a public officer forces entry, the law treats it as a fundamentally different, far more severe category of offense.
Because they have the power of the state behind them.
Precisely. Under Article 128, it is a simple violation of domicile, but there is absolutely nothing simple about the implications. It is the abuse of the sovereign power entrusted to that individual by the government.
That makes total sense. I always visualize this baseline restriction as the vampire rule.
The vampire rule, I like that.
It's a bit of a pop culture analogy, but the mechanism is identical. Think about it. A vampire could possess unimaginable physical strength, immortality, supernatural power.
But they can't just walk in.
Right. If they walk up to your front porch, they are biologically barred from crossing the threshold. They cannot enter unless they receive an explicit verbal invitation from the master of the house.
That's a really great way to look at it.
So the public officer is the vampire in this scenario. They have the backing of the entire justice system, but they are paralyzed at your doorstep.
Right.
To cross, they need either your direct invitation, which is your consent, or they need a powerful magical pass to override your authority.
And that magical pass is the judicial order, the search warrant.
Exact.
The vampire rule captures the strict binary of the situation perfectly. Without consent or a judicial order, the entry is legally void from the moment the boot hits the floorboards.
Wow.
The law actually penalizes 3 distinct movements within this unauthorized entry.
Okay, let's break those down. What's the first one?
The first is simply crossing the threshold against the will of the owner, just entering. That's a crime right there for a public officer without a warrant.
Just stepping foot inside.
Yes. The second elevates the intrusion. It's searching through papers or personal effects without consent once they're already inside.
So even if they got in somehow, digging through your stuff is a separate violation.
Correct. But the third punishable act reveals a really fascinating nuance about the psychology of defiance.
Ooh, tell me about that.
It penalizes an officer who enters surreptitiously, meaning sneaking in secretly. And then, once discovered, they refuse to leave after the owner demands it.
Wait, so that specific clause implies that the initial sneaking in isn't necessarily the full crystallization of the crime.
Right. It's the refusal to leave that really locks it in under this specific clause.
So if an officer sneaks through my back door, realizes they made a mistake, and sneaks back out before I see them, is that treated differently than if I catch them standing in my kitchen?
Well, the defiance is the key here. The law recognizes that a secret entry is a violation. But the crime reaches its true punishable severity under this specific clause when the state agent is caught red-handed.
And when the citizen asserts their authority.
Exactly. The citizen asserts their ultimate authority over the space by demanding the agent leave, and the agent says no.
That is wild.
That refusal is the ultimate manifestation of state overreach. It is the officer asserting that their uniform grants them a higher claim to your living room than your deed to the house.
That just feels so violating. What's the penalty for that level of arrogance?
The baseline penalty for this is called prison correctional in its minimum period.
Okay, let's translate that penalty. Prison correctional isn't just some dusty legal term. What does it actually mean for the officer on the ground? Like, what happens to them?
It translates to actual deprivation of liberty. We're talking about jail time ranging anywhere from 6 months and 1 day up to several years depending on the specific circumstances.
Wow, real jail time.
Yes. But, the physical incarceration is almost secondary to the accessory penalties.
Really? What could be worse than jail?
A conviction carrying prison correctional typically involves the suspension of the right to hold public office.
Oh, wow. So it's a career killer.
It completely strips them of the very authority they abused. The law doesn't just put them in a cell. It ensures they can never wear the badge or wield the power of the state ever again.
That is massive.
It is.
Yeah.
It's a structural amputation of a rogue element from the justice system, the system purging itself.
So the fortress walls are high, and the penalties for scaling them without permission are really severe.
Very severe.
But the law never operates in a vacuum, right? A pristine theory always gets messy when it hits the reality of a tense standoff on a front porch.
Oh, invariably. Theory and practice are two very different things.
So let's explore the gray areas where the vampire rule starts to blur, because the sources introduce a concept that I really have to push back on heavily.
Okay, let's hear it.
Because frankly, it sounds like a trap for the listener. It's this concept of the implied waiver.
Ah, yes, the implied waiver.
The doctrine states that while express opposition is preferred, if a homeowner remains silent when an officer enters, that silence can be legally interpreted as an implied waiver of their constitutional rights.
That is the legal precedent, yes.
You expect me to believe that if 4 heavily armed narcotics officers push past my front door and I freeze up in absolute terror, my paralyzed silence is considered legal consent? That is insane.
I completely understand the visceral reaction to that.
Right.
It feels deeply unfair.
It feels like the justice system is engaging in victim blaming. You're expecting a terrified citizen to suddenly become a constitutional scholar and debate an armed squad in their hallway.
It does feel that way. But we have to look at how courts, like in cases such as People v. Sane, analyze these events retrospectively.
What do you mean retrospectively?
Well, the court wasn't in the hallway with you. They were looking at a cold transcript of the event months or even years later.
But the court must understand basic human psychology. The fight or flight response often results in freezing. Why does the burden of friction fall on the citizen whose home is being invaded?
Because the legal system requires an objective, measurable standard to evaluate the interaction.
An objective standard.
Right. What's fascinating here is the tension between internal emotional states and external legal actions. The law requires a manifestation of will.
So you have to show it.
Exactly.
Yeah.
If an officer walks in and the homeowner stands aside, offers no physical resistance, and utters no verbal objection, how is the officer supposed to know you're terrified?
I mean, they should probably guess.
Maybe. But legally, how are they, or later a judge, supposed to distinguish between genuine cooperative consent and paralyzed terror?
That's tough.
The court in Sane established that an individual asserting a violation of their domicile must show they did not consent. You cannot retroactively claim your silence was a protest.
Wow, that places an astronomical burden on you, the listener. The takeaway here is brutal, but so necessary.
It really is.
Your silence is not a shield. You have to verbally construct that shield in the moment. You literally have to look the officer in the eye and say, I do not consent to this search. I want you to leave.
Yes. You must vocalize the boundary. If you just stand there hoping they'll go away, the state will absolutely argue you invited the vampire in.
That is terrifying, but so important to know.
Now let's pivot to a scenario where vocalizing your boundary actually doesn't matter at all.
Wait, there's a time when saying no doesn't work?
Yes. The exception for a lawful arrest. Jurisprudence, specifically highlighted in cases like U.S. versus Vallejo, dictates that an officer is allowed to break into a building or enclosure to effect a lawful arrest.
Ah, okay. This is the hot pursuit loophole.
Exactly.
So if an officer witnesses a mugging on the street and the suspect sprints away, runs up my driveway, and crashes through my front door.
The officer doesn't have to stop on your porch and wait for a judge to sign a piece of paper.
Right. They can just bust in after them.
The legal mandate to apprehend a fleeing suspect or to execute an active arrest warrant for someone verified to be inside overrides the sanctity of the closed door.
Because public safety is at immediate risk.
Precisely. The urgency of public safety temporarily supersedes the right to privacy. But I want to stress, this exception is a razor-thin tightrope. The officer must have absolute, legally justifiable grounds for the arrest. They can't just be guessing. Which brings us directly to the doctrine of mere suspicion, articulated heavily in U.S. versus De Los Reyes.
Right. Mere suspicion. This is where intuition clashes with procedure, isn't it?
It really is.
Because imagine a detective might have like 20 years on the force. They might have an incredible gut feeling that a specific house is a counterfeiting operation.
A feeling based on real experience.
Yeah. They see the weird hours. They see the strange chemical deliveries. Their instinct is just screaming at them that something illegal is happening.
Their instinct might be 100% correct. Instinct makes a brilliant detective, but it makes a terrible legal justification. De Los Reyes cemented the rule that mere suspicion, no matter how highly educated or historically accurate that officer's gut feeling might be, is never a sufficient basis for a warrantless search against the owner's will.
Never.
Never. The state's curiosity, or even its well-founded suspicion, cannot bypass the judicial gatekeepers. They still need the warrant.
This leads us to what I think is the most counterintuitive yet profoundly important philosophical stance in this entire legal landscape,
Which is?
the concept of the poisonous tree.
Ah, yes. The fruit of the poisonous tree.
Let's play out a hypothetical for the listener. So that detective with the gut feeling gets impatient. He knows he doesn't have enough solid evidence to convince a judge to give him a warrant.
He's stuck.
Right. So he decides to play the odds. He waits until nightfall, kicks the back door off its hinges, storms into the house without a warrant, and bingo. He hits the jackpot.
He finds the evidence.
He finds it all. The living room is stacked floor to ceiling with counterfeit currency and illegal firearms. He caught the criminals dead to rights.
Intuitively, society wants to reward that officer.
Of course, he took a risk, and he took dangerous criminals off the street.
The ends justify the means mentality is a very powerful societal reflex. We want the bad guys caught.
But the law, specifically drawing from the foundational dissent in Mankato versus People, violently rejects that reflex.
It does, completely.
The doctrine states that even if incriminating evidence is actually found, the warrantless search remains fundamentally, irredeemably illegal.
That's right.
The state cannot use that counterfeit money or those guns in a trial against the homeowner. It's like it doesn't even exist.
The Mankato dissent is honestly a masterclass in long-term legal philosophy. It forces us to step back and ask, what are we actually trying to protect here?
Right, because if they let the evidence in.
Exactly. If the courts allowed that counterfeit money to be submitted as evidence, they would be retroactively validating the officer's crime.
They'd be saying it was okay that he kicked the door down.
They would be sending a message to every law enforcement agent in the country saying, Article 128 is just a suggestion. If you break into a house and find nothing, sure, you might face a penalty. But if you break in and find the stash, you're a hero, and we'll just look the other way.
It creates a totally perverse incentive. It basically tells the police to gamble with our constitutional rights.
Exactly. By rendering the evidence completely inadmissible, by declaring it the fruit of a poisonous tree, the judicial system is prioritizing the integrity of its own process over the immediate gratification of a single conviction.
That is so powerful.
It is a structural deterrent. The law tells the officer, we don't care what you found. Because of how you found it, this evidence legally does not exist.
So it forces law enforcement to do the tedious, difficult work of building probable cause before they ever approach your porch. They have to do it the right way.
Precisely. No shortcuts allowed.
All right, to wrap up these gray areas, we have to look at the physical geography of this protection. Because the fortress has a perimeter, right?
Yes, and that perimeter has hard limits.
The case of People versus Ella establishes that the protection against the violation of domicile does not embrace a search outside of the dwelling.
The legal architecture of the dwelling is strictly construed. Your living room, your bedroom, your attached garage, these are the inner sanctums.
What about the yard?
That's exactly it. Your open yard, the shed near the property line, the driveway. The expectation of privacy dilutes significantly once you step out the front door.
But it's not a free fire zone for law enforcement out there, is it? I mean, just because an officer's standing in my garden doesn't mean they can do whatever they want.
Oh, far from it. While they might not be violating the specific sanctuary protections of Article 128, their actions are still governed by the broader penal code.
So they can still get in trouble.
Absolutely. If an officer starts, say, ripping apart your garden shed and uses violence or intimidation against you to do it, they escalate the situation to grave coercion under Article 286.
Grave coercion?
Yes. They are forcing you to submit to an illegal act through fear.
What if they're not violent? What if they're just annoying?
Even if they're entirely peaceful, but they're just tearing up your flower beds without any justification, causing you unwarranted annoyance, they face charges of unjust vexation under Article 287.
Unjust vexation. I love that term.
It's very descriptive. So the legal bubble is thickest inside the house, but a thinner membrane of property rights and personal liberty still covers your entire estate. You are never completely without protection.
Okay, here's where it gets really interesting. We've mapped the baseline and we've navigated the loopholes and the physical boundaries. Now we look at the escalation of the crime.
The aggravating circumstance.
Right. The law recognizes that an illegal entry isn't a static offense. It changes based on how the state agent behaves once they actually cross the line.
Yes, and if a public officer commits this crime under specific conditions, the penalty skyrockets.
Skyrockets to the medium and maximum periods of prison correctional.
Which is significant.
The first of these conditions is if the offense is committed at nighttime.
The law's focus on nighttime is a fascinating intersection of biology and jurisprudence.
Biology? How so?
Well, think about why the rotation of the Earth changes the severity of a crime. It's because nighttime is when the human animal is biologically programmed to power down.
Oh, that makes sense.
It is the time of sleep, of absolute vulnerability. The darkness amplifies the psychological terror of a sudden violent intrusion.
It's the difference between someone walking into your office unannounced at noon versus someone kicking your bedroom door open at 3 a.m.
Exactly.
The action is technically the same, but the psychological trauma is exponentially worse.
The law acknowledges that an illegal entry during the day is an abuse of power, but an illegal entry at night is the weaponization of terror.
Wow. Weaponization of terror.
The officer is exploiting the natural vulnerability of the sleeping household, magnifying the intimidation factor. Therefore, the state punishes the officer far more harshly for choosing the cover of darkness.
But the second aggravating circumstance, I think this one is even more insidious.
It is deeply personal, yes.
The penalty escalates if papers or effects that do not constitute evidence of a crime are taken and not returned immediately.
This happens more often than you'd think.
Let's put you, the listener, in this scenario. The rogue officer has bypassed the vampire rule. They are in your house, unlawfully. They are supposedly looking for, let's say, financial ledgers related to tax evasion, but instead of just looking at the filing cabinet in your office, they go into your bedroom.
A massive overstep.
They open your nightstand, they find your deeply personal handwritten diary, and maybe a box of old Polaroids from your childhood.
Things with zero evidentiary value.
Exactly. Items that clearly, undeniably, have zero connection to corporate tax fraud, and they put them in an evidence bag and walk out.
It is an act of profound voyeurism by the state.
It's sickening.
It really is. This clause is a beautiful demonstration of the law, recognizing that privacy isn't just about hiding criminal activity. It is about protecting the sanctity of the self.
The sanctity of the self.
The state has a mandate to investigate crimes. It has absolutely no mandate to rummage through your memories, your private thoughts, or your personal history.
When they take that diary, it feels less like an investigation and more like psychological warfare. Like they just want to hurt you.
The taking of non-evidentiary items is the ultimate power trick. It is the officer demonstrating that because they have breached your physical walls, they now own your personal narrative.
They are stripping you of your dignity.
Perfectly said. The law elevates the penalty for this because the harm shifts from a violation of physical property to a violation of the psychological core of the individual.
It's not just trespassing anymore.
No. The state is telling its agents, if you cross the line into personal voyeurism, the hammer will fall twice as hard.
So we've spent the first half of this deep dive dealing with the rogue officer, the cop who ignores the rules and forces their way in.
The one who acts without the warrant.
Right. But the narrative of state overreach takes a much darker turn when we look at Article 129. We are moving from the officer who breaks the system to the officer who weaponizes the system.
We are transitioning from a lack of paperwork to the abuse of paperwork.
Article 129 covers search warrants maliciously obtained and abuse in the service of those legally obtained.
The penalties here are fascinating.
Let's look at them. They combine physical deprivation of liberty arresto mare in its maximum period to prison correctional in its minimum period with a massive financial strike.
A hefty fine.
A fine not exceeding 200,000 pesos.
Which is a huge amount.
Why the massive fine here? Because the rogue cop who broke in without a warrant earlier didn't get hit with a 200,000 peso fine. Why is this financial penalty added now?
Because a search warrant is the most sacred instrument in criminal procedure. It is a direct written order from a judge.
It's the magical pass.
Right. When an officer abuses the warrant process, they aren't just violating a citizen, they're making a mockery of the judicial branch itself.
Oh, they're lying to the boss.
Exactly. They're using the judge as a pawn in their illegal scheme. The massive fine is the judicial system's way of punishing the insult to its own integrity.
That makes a lot of sense. The first punishable act here is procuring a search warrant without just cause. This requires us to look at the mechanics of how a warrant is actually born.
The procurement process.
Because an officer doesn't just print one out at the precinct, right? They have to convince a judge. And the currency they use to buy that warrant is called probable cause.
Probable cause. The jurisprudence surrounding this is massive. But cases like U.S. versus Addison, Coro versus Lysing, and Burgos versus Chief of Staff establish the rigid parameters.
What are those parameters? What actually counts as probable cause?
Well, probable cause cannot just be a hunch. It cannot be based on an anonymous tip without verification.
So no guessing.
No guessing. It must be a reasonable belief, grounded in specific facts and circumstances, presented to the judge under oath that a specific crime has occurred, and that the exact evidence of that crime is sitting in the specific location they want to search.
And the judge is supposed to act as an independent filter there.
That's their job.
The judge is the gatekeeper.
The judge is supposed to be cold, neutral, and detached. They're the friction point between the zealous police officer who wants to kick the door down and the constitutional rights of the citizen.
But what happens if the police officer lies to the gatekeeper?
That's the crux of Article 129.
What if they fabricate an informant or exaggerate the facts in their sworn affidavit?
That is malicious procurement. If an officer intentionally feeds poisoned information to a judge just to get that signature, they have committed the crime.
They tricked the system.
They have bypassed the constitutional protections, not by kicking the door down, but by tricking the judge into opening it for them.
And this brings us to the second, even more complex half of Article 129.
The execution of the warrant.
Let's assume the warrant is perfectly legitimate. The officer did their job, the evidence was real, the judge found probable cause, and the warrant was signed.
Everything is above board.
The officer is now legally standing in your living room. The second crime occurs when the officer exceeds their authority or uses unnecessary severity in executing that legally procured warrant.
This raises an important question. What exactly separates a vigorous search from unnecessary severity?
I want to introduce an analogy here to explain this concept of exceeding authority, because a legally procured search warrant is not a sledgehammer.
I like where this is going.
It is a highly specific, incredibly sharp surgical scalpel. It is a precision tool granted by the judge to extract very specific evidence. Just because the state has authorized you to operate doesn't mean you get to amputate whatever you want.
The scalpel analogy is perfect, and it is precisely how the Supreme Court viewed the situation in Uy-Ketten versus Villarreal.
How so?
A warrant must describe with particularity the things to be seized. If the judge signs a warrant authorizing the police to search your home for a stolen grand piano, the officers are legally allowed to walk through your front door.
Right. They can look in your living room, they can look in your garage.
But they absolutely cannot open your desk drawers.
Because you can't hide a grand piano in a desk drawer.
Exactly. It's physically impossible. If an officer uses the piano warrant as an excuse to start rifling through your financial files or your jewelry boxes, they have dropped the scalpel and picked up the sledgehammer.
They've gone totally out of bounds.
They've exceeded their authority, and their search immediately transforms into a criminal act under Article 129.
And the unnecessary severity clause addresses the physical reality of the search. Because, let's face it, the police are inherently intrusive. Searching a house makes a mess.
It does. It's not a gentle process.
But there is a line between a thorough search and a punitive rampage.
Exactly. If the warrant is for illegal firearms hidden in the walls, the police might legally have to break some drywall. That is a necessary severity.
They have to look in the wall.
But if they're looking for tax documents on a flash drive, they have absolutely no justification for slashing your mattresses open or smashing your television.
That's just destruction for the sake of destruction.
When the destruction of property becomes disproportionate to the objective of the search, it becomes a crime. The state is penalizing officers who use a valid warrant as a cover story to simply terrorize a citizen and destroy their home.
And the ultimate fail-safe against all of this, the weaponized warrants, the sledgehammer searches, it brings us back to the exclusionary rule.
The poisonous tree again.
Right. The landmark cases of Ali versus Castro and Stonehill versus Diokno cement the finality of this doctrine.
Stonehill is particularly vital here.
Tell us about Stonehill.
It involved massive sweeping warrants issued against a vast network of corporations. The warrants basically authorized the state to seize every document in the building to look for tax evasion.
Just grab everything.
Grab everything and see what sticks. But the Supreme Court slammed the door on that practice. They ruled that general warrants that essentially say, go find something illegal, are unconstitutional.
Because they lack the scalpel. They lack the particularity.
Exactly. And when officers execute a general warrant, or when they exceed the authority of a specific one, the evidence is legally dead. It is completely inadmissible.
So we have built a massive legal structure here. We understand the rogue entry. We understand the weaponized warrant. Now we reach the final stage of our deep dive.
Section 5.
The witness mandate, detailed in Article 130. This is where the law creates a procedural hurdle that feels almost quaint.
Quaint is a good word for it.
Yet it is arguably the most brilliant anti-corruption mechanism in the entire penal code.
To understand the power of Article 130, we have to imagine the perfect scenario. The officer hasn't lied. They have rock-solid probable cause.
The judge issued a highly specific, perfectly constitutional warrant.
The officer arrives at your house during the daytime. They're a model of professionalism. They have the absolute unassailable legal right to turn the doorknob and walk in.
But the law says, no, stop. You are missing one final piece.
Article 130 criminalizes the act of searching a domicile without witnesses.
Without witnesses.
It imposes a penalty of arresto mea on an officer who searches a home, papers, or belongings in the absence of the owner.
Okay, so the owner has to be there. What if they aren't?
If the owner isn't there, a family member must be present. But the truly fascinating legal mechanism activates when the house is entirely empty.
The family's on vacation.
Right. If the owner and the family are gone, the officer cannot enter without the presence of TDO witnesses who reside in the same locality.
Let's really break down the mechanics of this. Why 2 witnesses? And more importantly, why specifically from the same locality?
It's a very specific requirement.
If I'm a police detective with a valid warrant for an empty house, why can't I just grab 2 rookie cops from the patrol car, have them stand in the living room, and call them my witnesses?
If we connect this to the bigger picture, this is about the creation of the independent auditor.
An auditor for the police?
Yes. The justice system understands that a search is an inherently opaque process. When state agents are alone in a citizen's home, the power dynamic is absolute. There is zero external accountability.
Because nobody is watching the watchers.
Exactly. Who is to say what the house looked like before they entered? Who is to say a bag of contraband wasn't carried in the officer's pocket?
It's the classic fear of planted evidence.
Precisely. But explicitly mandating 2 witnesses from the same locality, meaning the neighbors, the people from the local barangay, the civilians who live on that very street.
The law is enforcing mandatory, localized community oversight.
The police are forced to break their operational bubble. They have to physically knock on the door of the homeowner's neighbor and say, "We represent the state. We have a warrant for the house next door.
Right.
We are compelling you to come inside and watch our hands."
That is a brilliant anti-framing mechanism. It is exponentially harder for a corrupt narcotics detective to plant drugs in an empty bedroom if the suspect's next-door neighbor is standing in the doorway watching his every move.
It makes planting evidence nearly impossible without a massive conspiracy. But the beauty of the witness mandate is that it cuts both ways.
What do you mean?
It protects the absent homeowner from planted evidence, sure, but it equally protects the honest police officer from false accusations.
Oh, I didn't even think of that.
Imagine a clean squad executes a perfect search on an empty house and seizes an illegal firearm. The homeowner comes back and falsely claims the police stole 50,000 pesos from my safe while it was gone.
The police have an alibi.
They have 2 independent civilian neighbors who can testify under oath. No, we watched the entire search. The officers touched nothing but the firearm.
That's brilliant.
It removes the he said, she said dynamic between the state and the accused. It forces transparency into the most private, vulnerable moment of the criminal procedure.
Now, the sources provide some crucial nuance to this rule. The fortress mentality applies to the domicile, but the law recognizes that we don't just live in houses.
Right, we move.
We move. The text explicitly notes that Article 130 is not applicable to searches of vehicles or other means of transportation.
This circles back to the core philosophy of the expectation of privacy. A stationary home is rooted to the earth. It isn't going anywhere.
But a car on a public highway is highly mobile.
Exactly. If the police pull over a vehicle suspected of carrying contraband, they are operating under extreme urgency.
Because the evidence could just drive away.
Yes. If they had to pause the search, leave the highway, and go canvass the local neighborhood to find 2 civilian witnesses to watch them search the trunk,
the vehicle would be long gone and the evidence lost.
the law balances the urgency of the mobile threat against the expectation of privacy and waives the witness requirement for vehicles.
But the text is very quick to defend the physical home one last time, even against the most powerful federal agencies. It brings up the Tariff and Customs Code.
Customs. They have incredibly broad powers.
Notoriously broad. They can search ships, cargo containers, and warehouses with incredible leeway, looking for smuggled goods. But citing the landmark case of Papa versus Mago, the law draws a hard line in the sand.
Papa versus Mago is the ultimate reaffirmation of the fortress.
It really is.
It dictates that even with the vast sweeping powers granted to customs enforcement, Those warrantless search powers absolutely die at the front door of a dwelling.
They stop at the porch.
A customs agent cannot use the suspicion of smuggled goods to bypass the judicial process and breach a private home. The domicile remains the hardest boundary to cross in the entire legal system, regardless of which badge the officer is wearing.
So what does this all mean? We have navigated an incredibly dense, highly structured legal labyrinth today.
We covered a lot of ground.
But a very clear, very powerful narrative has emerged. The criminal justice system constructs a massive, multi-layered, heavily armed fortress around your physical home.
It really does.
It doesn't just ask law enforcement to respect your privacy, it threatens them with the destruction of their careers and their own liberty if they don't.
The penalties are the teeth of the law.
Article 128 penalizes the rogue cop who steps inside without permission. Article 129 unleashes massive fines and jail time on the cop who lies to a judge to get a warrant, or who uses a valid warrant to wage a destructive campaign against your property.
And Article 130 demands strict, independent community oversight through your neighbors, even when every single piece of police paperwork is completely flawless. The overarching takeaway for you, listening to this, is that this architecture of protection only works if you understand it.
You have to know your rights.
Exactly. In a modern era, where the state feels omnipresent, where surveillance is ubiquitous, knowing the precise mechanics of these laws is your ultimate defense.
It's how you level the playing field.
It is how you level the playing field against an armed agent of the government. Knowing that your silence can be weaponized as consent empowers you to find your voice.
To speak up and say no.
Knowing that an officer's gut feeling is legally worthless empowers you to demand the warrant. Knowing that a warrant is a scalpel, not a sledgehammer, empowers you to hold the officers accountable for what they break.
The law desperately wants your home to remain a sanctuary.
But it requires you, the citizen, to act as the primary guard at the gate.
We've spent this entire deep dive talking about physical space. We've talked about deadbolts and front porches and written diaries and physical search warrants.
A physical world.
But I want to leave you with a final provocative thought to mull over. Our physical lives are shrinking, and our digital lives are expanding exponentially.
Well, that's a really interesting point.
We don't keep our most intimate secrets in a wooden nightstand anymore. We keep them in cloud servers, in encrypted messaging apps, and in biometric digital wallets.
The very definition of the domicile is undergoing a radical, unseen evolution.
Exactly. The laws we discussed today, Articles 128, 129, and 130, were written for a world of wood, brick, and paper.
They were written decades ago.
So the question we have to ask ourselves as we move forward is this: how will this exact same legal fortress translate to our digital domiciles?
How do you get a warrant for a cloud server?
Right. If a state agent uses a malicious algorithm to bypass your encryption without a specific warrant, or if they use unnecessary severity to rip apart your entire cloud architecture looking for a single email.
Will the justice system protect the invisible code of your digital home with the exact same ferocity that it protects the physical wood of your front door?
Will we have to invent new digital neighbors to audit the searches of our data?
It is the legal frontier of our time.
It's definitely something we're going to have to figure out soon. Something for you to think about the next time you look at the lock screen on your phone. Thanks for joining us on this deep dive. We'll see you next time.
Welcome to the debate. So imagine for a second that it is 2 o'clock in the morning, you are sound asleep in your bed, and suddenly there is this loud, authoritative knock at your front door.
Terrifying.
Right? It's the worst case scenario. You walk over, look through the peephole, and you see an armed police officer standing on your porch. In that exact moment, your heart rate it spikes.
Oh, absolutely. Total panic.
Exactly. And the only thing separating you from the absolute raw power of the state isn't just, a piece of wood and some metal hinges. It is a barrier constructed entirely out of complex legal architecture.
Yeah, an invisible shield, basically.
Yes. And today we are examining the profound philosophical friction embedded in that exact moment at the door. We're looking at Articles 128, 129, and 130 of the penal framework.
Right.
These are the specific statutes governing domiciliary searches, the violation of domicile, and the abuse of search warrants.
Yeah, and I think the fundamental question we have to answer here is, well, it's about how a society actually operates when the rubber meets the road. I mean, does this legal framework fundamentally prioritize the absolute sanctity of the home and your individual privacy against state intrusion?
Right.
Or on the flip side, does it primarily function as a pragmatic operational manual, a blueprint that actually facilitates, choreographs, and legitimizes the state's power to enter your life?
Well, I represent the perspective that this framework acts as a rigid, uncompromising shield. When you read the actual text of these articles, they are built to fiercely defend individual liberty.
Okay.
They protect the physical and psychological sanctity of the domicile against literally any government overreach.
And, well, my perspective is that reading the text reveals the exact opposite.
Really? The exact opposite?
Yeah, the exact opposite. These articles prioritize state action. They provide structured, highly conditional pathways for lawful intrusion, which demonstrates that the system is focused entirely on procedural compliance, not over any absolute concept of privacy.
Okay, well, to truly understand the gravity of these laws, we have to look at the sheer paranoia the legal system has toward its own agents.
Paranoia is a strong word.
But it fits. We're talking about the state literally threatening to imprison its own police force to protect the citizen's front door. Look at Article 128. It strictly criminalizes a public officer who enters a dwelling against the owner's will without a judicial order.
Right, a judicial order.
And the penalty isn't just, a slap on the wrist or some administrative fine. The penalty is prisión correccional.
Which is pretty severe.
Exactly. For our listeners, in practical terms, that means an officer is facing anywhere from 6 months to 6 years in actual prison for stepping over your threshold illegally.
Wow, 6 years.
Yeah. And Article 129 goes even further, severely punishing officers for maliciously obtaining warrants or using unnecessary severity. The baseline assumption of the law is absolute restraint. The state is telling its officers, you have no inherent right to cross that boundary, and if you do, we will lock you up.
Okay, look, the threat of prison sounds impressive on paper. Absolutely. But you have to look at the massive, gaping conditionals built right into that very same framework.
Gaping conditionals? Where?
Well, you're describing a rigid shield, right? But the text reveals a system completely designed to accommodate law enforcement, not to shut them out. You mentioned the prohibition against entering against the owner's will.
Right, that's the core of it.
But jurisprudence explicitly states that silence may be implied waiver.
Well,
that is a staggering loophole. Furthermore, the supposed absolute physical sanctity of the home is basically dismantled by the fact that officers are explicitly allowed to break into a building or an enclosure to effect a lawful arrest.
But that's only in specific...
Let me just finish this thought. Because when we look at Article 130, which strictly requires civilian witnesses for a search, those rules conveniently vanish the second we start talking about vehicles or transportation.
Right, vehicles are different.
But it shows this framework isn't a shield. It's a step-by-step choreography. It dictates exactly how the state is allowed to breach your privacy, proving that the sanctity of the domicile is highly subservient to whatever the state's operational needs happen to be on, any given Tuesday.
Okay, let's break down that concept of the threshold, because I think you're misinterpreting the baseline rule by focusing heavily on the exceptions.
I don't think they're just exceptions, though.
Well, think about modern digital privacy on your smartphone. You have it locked down with biometric security, facial recognition, two-factor authentication.
Sure.
Someone can't just swipe the screen and rifle through your emails. They need your explicit passcode, or they need the tech company to execute a master override.
Right.
Article 128 treats the physical home exactly like that locked device. The door only opens in two highly specific ways. Either you voluntarily provide the passcode by consenting, or the officer arrives with a highly specific master override, which is a warrant signed by a judge.
Okay, I follow the analogy.
And if an officer decides to bypass that, if they enter surreptitiously and refuse to leave, they trigger that penalty of up to 6 years in prison. The law views the physical boundary of the home as an absolute barrier.
Wait. If the law truly treats the home like a securely locked smartphone, how can you possibly defend the silence's implied waiver concept?
Well, silence...
A smartphone doesn't unlock just because you stared at it in silent, paralyzed terror.
That's a bit dramatic.
But let's go back to that 2 a.m. scenario at the front door. Think about the intense psychological reality of that dynamic.
Okay.
An armed public officer in full uniform is standing on your porch, demanding entry. The average citizen is going to freeze. They might be terrified into absolute silence.
Right, but
If your home is a true fortress with a rigid shield, that shield doesn't magically drop just because the homeowner is too frightened to articulate a legal objection. But under this framework, the officer can legally interpret your fear-induced paralysis as an invitation.
no, that's not what implied waiver means in practice.
The state is actively exploiting human psychology and the inherent power dynamic of a badge and a gun. It transforms the citizen's fear into a legally valid pathway for the state to enter.
Look, the law operates on the assumption that citizens possess agency. It explicitly requires express or implied opposition to be violated.
But fear removes that agency.
The framework can't operate on the presumption that every single citizen is utterly paralyzed. It requires a standard of interaction. If you don't want them in, you must deny them entry.
But even if we grant the citizen perfect agency and composure, right? What happens when the state simply decides its need to capture someone is more important than your physical barrier?
You're talking about lawful arrests now.
Yes. The framework explicitly dictates that breaking into a building or enclosure is allowed to effect a lawful arrest. The state doesn't need your consent, implied or explicit.
Well, obviously, if they are chasing a fleeing...
And they don't even need a specific search warrant for the house if they are there to make a lawful arrest. They can literally kick the door off its hinges, shatter the windows, and force their way in.
That's...
How can you call it a rigid shield when the state explicitly grants itself the authority to smash the barrier whenever it deems an arrest necessary?
Because the authority to break in for a lawful arrest is an incredibly narrow exception born of absolute time-sensitive necessity. It is not a general waiver of privacy.
It's a pretty big exception.
And frankly, we need to look at what happens once the state actually crosses the threshold, because this is where the shield becomes undeniably thick.
Okay, tell me about the inside.
Even if an officer is legally inside, look at how fiercely the law protects the papers and effects of the individual. Under Article 128, the penalties are aggravated. Like, they are pushed to the maximum periods of prison time if the offense is committed at nighttime. Or, importantly, if papers not constituting evidence of a crime are not returned immediately.
I want to pause on that. Why is the distinction between daytime and nighttime so critical to your argument about the shield?
Because it exposes the underlying philosophical intent of the law.
How so?
Nighttime is when the individual is most vulnerable, right? When the domicile is functioning most intimately as a place of rest, retreat, and family life.
Okay, sure.
By explicitly aggravating the penalty for nighttime violations, the law acknowledges the deep psychological sanctity of the home. It isn't just treating the house as a physical box of evidence, it's protecting the human condition inside it.
I see what you're saying.
But look at the mandate, to immediately return papers that aren't evidence. That is a direct, targeted strike against state fishing expeditions.
Right.
The state is telling its officers, you cannot use your lawful access to rifle through a citizen's private life. If a document doesn't prove a crime, you give it back right now or you go to jail. That is a framework obsessed with defining and protecting the boundaries of the individual's private sphere.
Okay, I'll agree that the law defines boundaries. But those boundaries are entirely geographically engineered to serve the mobility of law enforcement.
Geographically engineered?
Yeah. You are focusing strictly on the interior of the dwelling, the bedroom at night, the personal papers. But what happens when we literally step off the porch?
Well, you're in public.
Right. The moment you leave the physical structure of the home, the protections basically evaporate. The jurisprudence is incredibly clear here. A search outside of a dwelling is not even embraced by the definition of a search under Article 128.
Yeah, but it doesn't mean the police can do whatever they want.
It definitely lessens the barrier.
It still falls under grave coercion if they use violence to search you, or, unjust vexation if they harass you without violence. Both of those carry criminal penalties and fines.
True, but they are fundamentally downgraded penalties compared to the draconian threat of prison correccional for entering a home.
Well, the home is special.
Exactly. But let's look at the most glaring example of this spatial engineering. Vehicles.
Oh, here we go with the vehicles.
Yes. Under Article 130, you have incredibly strict rules requiring civilian witnesses for a search of a domicile. But the law explicitly states those rules do not apply to searches of vehicles, vessels, or aircraft.
Because they move.
Exactly. A warrantless search under the Tariff and Customs Code is strictly prohibited inside a dwelling, but out on the highway, the rules fundamentally change. Why? we have to understand the mechanics of exigent circumstances.
Right.
A house is static. It's bolted to the foundation. An officer can secure a house and wait 6 hours for a judge to sign a warrant. But a vehicle is moving at 60 miles an hour.
Obviously.
The half-life of evidence inside a moving car is measured in minutes. It can cross a jurisdictional border before a judge even picks up a pen. So the state removes your privacy shield on the road entirely because it needs the flexibility to intercept.
But that's just practicality.
The entire concept of privacy here isn't based on an absolute philosophical purity like you're claiming. It's spatially engineered to ensure the state can police efficiently. The home is protected primarily because it isn't going anywhere. Once you become mobile, the state's operational manual completely overrides your right to be left alone.
Look, you're treating the vehicle exception as if it exposes the whole system as a fraud.
It does expose the intent.
No, the foundation, the absolute baseline of the framework is severe restraint. If this framework is merely a pathway for state action, as you claim, why does the state intentionally hamstring its own officers, even when they have followed the manual perfectly?
How exactly is the state hamstringing its own agents?
Look closely at the mechanics of Article 130.
Okay.
Let's say an investigator has done everything right. They have gathered evidence, gone to a judge, established probable cause, and the judge hands them a legally procured search warrant.
They have the green light.
Right, the state has given them the absolute legal green light. But when they arrive at the house, if the owner is absent or if no family member is present, the officers still cannot just turn the doorknob and search the place.
They need witnesses.
Exactly. They are legally required to scour the neighborhood and find 2 civilians residing in the same locality to act as witnesses. Think about how difficult that is in practice. You have to find 2 random neighbors willing to walk into a potentially dangerous crime scene just to watch the police. The state is literally pausing its own legally sanctioned investigation to ensure there are civilian eyes monitoring its officers.
Okay, but...
And wait, if the police say this is too much hassle and search anyway, the penalty is arresto mayor, 1 to 6 months in jail. But the ultimate undeniable proof that this is a shield is the exclusionary rule.
The exclusionary rule is fascinating in theory, but we really need to dissect how it actually operates.
Well, we have to look at the history here first. The principles established in landmark cases like Stonehill vs. Diocno and Alla vs. Castro are the absolute enforcement mechanisms of this entire legal universe.
Okay, lay it out.
In Stonehill, you had massive coordinated raids on corporations using general warrants, which were basically blank checks for the police to seize anything and everything.
Right.
And the Supreme Court stepped in and said, absolutely not. They ruled that illegally seized documents, papers, and things are completely inadmissible in evidence. Think about the immense gravity of that mechanism.
It is heavy.
Right, a police officer could execute a search and find the murder weapon, the bloody clothes, the written confession, the physical proof of guilt. But if they procured that warrant maliciously under Article 129, or if they were too lazy to get their 2 local witnesses under Article 130,
The evidence is out.
yes, that murder weapon mathematically ceases to exist in the eyes of the court. The legal system will literally throw away perfectly good, undeniable evidence, lose a major conviction, and let a guilty person walk free, rather than validate an unjust search. A system that is purely an operational manual for state power would never, ever throw away a murder weapon just because a procedural rule was broken. It punishes the state by destroying its own case.
Okay, that is undeniably the strongest theoretical version of your argument. The exclusionary rule on its face sounds like an ironclad defense. It's the ultimate trump card.
It is. But we cannot just read the case law in a vacuum. We have to examine the practical, operational reality of how these rules are applied on the ground every single day. Let's unpack Article 129 and the malicious procurement of warrants.
Okay.
The law says procuring a warrant without just cause, which practically means without probable cause, results in a penalty and a fine of up to 200,000 pesos.
Right, which is a massive deterrent. It tells the officer do not lie or stretch the truth to a judge or it will literally bankrupt you.
In theory. But what actually is probable cause?
Well, It is an incredibly malleable concept. It is not an absolute, scientifically verifiable barrier. Probable cause is a narrative.
A narrative?
Yes. An officer simply has to gather enough circumstantial data, arrange it in a compelling timeline, and write a persuasive enough affidavit to satisfy a magistrate.
Well, the judge still has to agree.
Sure, but the framework doesn't stop the state from investigating you. It just demands that the officer write down a structurally sound story first. And let's revisit your point about the 2 local witnesses in Article 130.
The civilian witnesses, right?
You call that the state hamstringing itself. I call it the state explicitly immunizing itself.
Wait, immunizing itself? By creating a massive administrative obstacle right in the middle of an operation?
It's not an obstacle, it's a built-in validation mechanism. When the officer grabs those 2 local civilians from the neighborhood, those witnesses aren't there to audit the search.
They're there to observe.
But they don't have law degrees. They don't have the power or the expertise to analyze the legality of what the police are doing with those papers. They are props.
Oh, come on.
They are. They are there so that the state can march into court later and say, "Look, Your Honor, we checked the box, we have the signatures, we followed the choreography." As long as the officers check the right procedural boxes, getting the 2 witnesses, ensuring the search happens during the daytime so it doesn't trigger the aggravating circumstance, they are completely shielded from liability under this framework.
But
the rules do not exist to prevent the search from happening. They exist to dictate exactly how the search must be conducted so that the state's actions are entirely unimpeachable in court. It is a highly detailed manual for lawful intrusion. The exclusionary rule only punishes the sloppy officers who fail to read the manual.
but even if they follow the manual perfectly, if the officer uses unnecessary severity in executing that legally procured warrant, Article 129 still punishes them.
True.
Even when they have the absolute green light, even with the witnesses present, they are constrained by a standard of proportionality. They can't just tear the house apart for the sake of it.
Proportionality dictated by whom, though?
By the courts.
By the state itself? The penalties exist to discipline officers who deviate from the blueprint, not to stop the blueprint from being executed.
I disagree with that framing.
If an officer enters your home, they have by definition breached your privacy. The fact that they did it politely with 2 terrified neighbors watching during the daytime doesn't change the fundamental reality that the state has designed a perfectly legal mechanism to bypass your so-called absolute privacy. Your fortress has a backdoor built right into the architectural blueprints, and the state holds the master key.
But the key is held by the judiciary, not the police. That is the critical separation of powers that ensures the shield remains intact. The police cannot authorize their own entry. They must convince an independent branch of government.
But the police are the ones who gather the evidence, shape the narrative, control the flow of information, and present it to the judge.
Well, they're the investigators.
Right. So the framework relies heavily on the integrity and the procedural competence of the public officer, the very entity the framework is supposedly protecting the citizen against.
Look, when we look at all these pieces together, the severe statutory penalties, the precise mechanisms for obtaining a warrant, and the sheer destructive power of the exclusionary rule, I still see a system whose primary, overriding goal is protecting the citizen.
I just don't see it that way.
The threat of years in prison for violating the domicile and the willingness of the courts to throw out valid evidence to punish bad procedure points to a legal philosophy that fiercely values the physical and psychological sanctity of the home against government overreach.
And when I look at those exact same mechanisms, I see a highly pragmatic, deeply unsentimental system calibrated to facilitate state policing powers.
You really think it's just an operational manual?
Absolutely. The exceptions are simply too structural to ignore. The psychological reality that silence can act as an implied waiver, the explicit violent permission to break into a building to effect a lawful arrest, and the geographic reality that removes these strict protections the moment you get into a car. All of it demonstrates that this is an operational manual. It is a complex set of instructions telling the state exactly how to lawfully breach your privacy.
Well, I think where these two perspectives genuinely intersect is on the sheer complexity of the design.
Oh, for sure. It's incredibly complex.
Right. We are looking at a legal framework that acts as an incredibly delicate, highly technical balancing act.
It operates precisely on the tension wire strung between a citizen's fundamental human right to be left alone and the state's existential mandate to uncover criminal activity and maintain order.
Absolutely. Every single clause we've discussed today, from defining nighttime as an aggravating circumstance based on human vulnerability to the logistical nightmare of requiring 2 local witnesses, is a deliberate attempt to calibrate that tension. It is a fascinating, ongoing negotiation of power.
It really is. And it speaks to the value of reading these legal statutes not just as dry academic rules to be memorized for a bar exam, but as profound philosophical boundaries.
Exactly.
These laws define the exact nature of the relationship between the individual and the state. They force us to ask exactly what we are willing to trade for our collective security and what we absolutely demand to keep for our own individual liberty.
Yeah, the penal code isn't just a list of punishments. It is a mirror reflecting exactly what a society values at any given moment in history.
Beautifully said. And I'd highly suggest our listeners dive into the source material further to see where their own definitions of privacy intersect with these protocols.
Highly recommend it.
Think back to that 2 a.m. knock on the door we talked about at the beginning. If your home is truly your private sanctuary, who really holds the master override? And under what specific circumstances are you truly comfortable with the state letting themselves in? We will leave you to ponder that. Thank you for joining us on this discussion.